Dear Mr. Tavares, delegates from co-organizers of Hong Kong Maritime Law Association, HKMAG, Institute of Chartered Shipbrokers, and CIRB East Asia Branch, teams of arbitral tribunals and counsel. Ladies and gentlemen, thank you for visiting CTAC Hong Kong Arbitration Center to observe mock arbitrations on maritime disputes. This is the 5th year in a row that we host audience from shipping and legal industry to appreciate what may happen in a hearing room when parties try to resolve disputes via efficient and tactical use of arbitration. 5 years ago, Department of Justice, HKMLA, HKMAG, HKIRB, CIRB East Asia Branch, and us decided to pull resources together and create something useful, practical, and more importantly, unique for users of maritime dispute resolution in the Maritime Week, which was, as you may know, at that time, already packed with interesting seminars and fantastic social activities. The mock arbitration will always contain both procedural and substantive matters so that the audience from both legal and shipping industry can enjoy that. This is how this got started in the year of 2018, and I can still remember that many of us today actually gathered at the DOJ function hall to witness the first year mock arbitration. In the year of 2019, with enhanced security check, we managed to host the second mock arbitration at a difficult time for Hong Kong, again at DOJ function hall. 1 year later, in the year of 2020, also known as year one after COVID, we still achieved to host the third mock arbitration at DOJ function hall. With support from DOJ, staff, technicians, and CTAC Hong Kong Arbitration Center's case management team, at that year we even tried for the first time engage more than 500 people online and on-site to enjoy the mock arbitration. At that time, in the year of 2020, hybrid event was not as easy to run as it is today, but we made it. It was also at that year we aimed to make sure that every year's mock arbitration is timely in theme and reflects what is happening in the real world that affects industries. That year, the mock arbitration reflected the real difficulty parties face in the hearings in the COVID. Therefore, practical in content, unique in style, and timely in the theme are all the reasons people reach to this mock arbitration event. In the year of 2021, when the world is going back and forth against COVID, I would say we still managed to go forth. The Hong Kong Legal Hub welcomed many talents, including us, CTAC Hong Kong Arbitration Center and CMAC Hong Kong Arbitration Center. It was the first year of 2021 we ran the event actually physically at the Legal Hub. Fast forward to today, we're extremely delighted to welcome you here to attend physically when we celebrate the life of Hong Kong gradually coming back to normal and salute to people's preference of face-to-face meetings. We make this event on-site only. And ladies and gentlemen, I just took you to the journey of how these mock arbitrations run in the past 5 years. Not to make it self-centered, but in China, we have a saying, 叶落知天下秋, or 一落知天下秋. A falling leaf is the herald of autumn. A journey of these mock arbitrations actually reflect how strong and resilient dispute resolution groups in Hong Kong are. And we are ready to roll up our sleeves and get back to work. So in the past few weeks, tribunals and counsel have actively engaged in the preparation of the mocks in an amicable way, I would say. And I hope you enjoy it, and I know I will enjoy it. So thank you very much again, and now I invite for the opening remarks, Principal Government Counsel, Legal Enhancement and Development Office, ladies and gentlemen, Mr. Clifford Tavares.
Thank you, Brad, for the introduction. I said okay. Brad, distinguished guests, ladies and gentlemen, it gives me great pleasure to welcome you all to this session of mock arbitrations on maritime disputes in the Hong Kong Maritime Week 2022. I was also given the honor to speak here last year. I'm very delighted to see you, everyone here in person this year. I'd like to express my sincere thanks to the co-organizers, CITEC Hong Kong Arbitration Center, CIMEC Hong Kong Arbitration Center, Hong Kong Maritime Arbitration Group, Hong Kong Maritime Law Association, Institute of Chartered Shipbrokers Hong Kong Branch, and Chartered Institute of Arbitrators East Asia Branch for holding this meaningful event once again. This is meaningful because this exercise helps promote the use of arbitration for maritime disputes by live demonstration of how it is done. As a session for just 2.5 hours, this mock hearing is carefully designed to cover both the procedural and substantial aspects of an arbitration, with seasoned practitioners as well as young and bright advocates participating. The Hong Kong government attaches great importance to nurturing young legal and shipping talents. Today's mock hearing greatly contributes to capacity building and training for practitioners and students in maritime arbitration. Maritime trade has always been one of the strengths of Hong Kong, being the gateway to mainland China. According to Xinhua Baltic International Shipping Center Development Index Report 2022, Hong Kong has been ranked 4th as an international shipping center for the 3rd consecutive year. In the latest edition of the United Nations Conference on Trade and Development Review of Maritime Transport, Hong Kong is ranked among the top in many areas, for example, in the aspect of a ship-owning economy, flags of registration by tonnage, liner shipping connectivity index, and so on. With such comprehensive and scale trading activities, conflicts and disagreements will inevitably arise. As the Secretary for Justice has said at a legal forum under the Hong Kong Maritime Week this Monday, Hong Kong possesses the credentials to offer full-fledged and quality arbitration services to the maritime industry. Indeed, our arbitration services have proven to be effective means in resolving cross-border and often complex and technical maritime disputes. In gist, Hong Kong has strong policy support at both the national level and the local level. At the national level, the National 14th Five-Year Plan and the GBA Development Plan set out clearly the Central People's Government's full support for Hong Kong to develop and enhance its status as an international transportation and maritime center. Hong Kong is also a renowned international center for legal and dispute resolution services, being one of the 8 centers highlighted in the National 14th Five-Year Plan. One of the pillars of Hong Kong's success is our common law system, which is preserved by the fundamental principle of one country, two systems. President Xi Jinping had delivered an important speech at the celebration of the 25th anniversary of the establishment of Hong Kong SAR on the 1st of July this year. In his speech, President Xi expressly confirmed that the principle of one country, two systems must be adhered to in the long run, and the Central People's Government fully supports Hong Kong to maintain the common law system. This dispels any previous doubt about the future of Hong Kong and paves the way to our long-term stability. In maritime contracts, English law is often adopted as the substantive law. As Hong Kong will continue to practice common law, which is based on English law, Hong Kong law indeed can be a good option for maritime contracts. Our lawyers with common law background will continue to provide professional and pragmatic services to clients in the maritime world. At the local level, the Hong Kong SAR government also gives dedicated support on many fronts. Among various aspects, I highlighted in my speech last year the importance of talents as well as the necessity of a forward-looking mindset in developing and enhancing the status of Hong Kong as an international maritime and dispute resolution center. These values still hold true, and perhaps it would be a good opportunity for me to highlight some of the important developments showcasing our continuing efforts in improving arbitration services in Hong Kong. Arbitral awards made in Hong Kong are generally upheld by local courts and enforceable in many other jurisdictions under the New York Convention. We also enjoy the benefits of various arrangements on mutual legal assistance in civil and commercial matters signed between the mainland and Hong Kong. Of groundbreaking importance to arbitration is the availability for interim measures in aid of arbitral proceedings for protection of property, evidence, and conduct preservation. Parties to arbitral proceedings seated in Hong Kong and administered by designated arbitral institutions may now seek assistance from the relevant courts in the mainland to obtain interim measures such as injunctions or freezing of assets. This has become a popular and effective tool for arbitration users to secure the fruits of success across the border. Another important arrangement, as updated in 2020, is on the mutual enforcement of arbitral awards between the mainland and Hong Kong, under which the arrangement has been refined to bring it more in line with the prevailing practice of international arbitration. Another recent encouraging development is the introduction of outcome-related fee structures for arbitration officer in Hong Kong. Officer, in simple terms, would allow lawyers and clients to agree on fee arrangements flexibly based on the outcome of the arbitration case. The Arbitration and Legal Practitioners Legislation Outcome-Related Fee Structures for Arbitration Amendment Ordinance 2022 was enacted on 22nd of June this year. The subsidiary legislation which sets out the more detailed regulatory framework and particular safeguards on officer was introduced into the Legislative Council earlier this month and would hopefully commence operation by the end of the year after the negative vetting procedure. The full implementation of the officer regime will allow Hong Kong to keep up with the latest practice in international arbitration by creating a level playing field with competing jurisdictions offering similar funding options for arbitration. I'm sure this move will be welcomed by maritime clients and practitioners. We have also reviewed the pilot scheme on facilitation for persons participating in arbitral proceedings in Hong Kong, which was launched in June 2020. Under the scheme, foreign nationals may visit Hong Kong visa-free and participate in arbitral proceedings in Hong Kong without the need to obtain an employment visa. Now we are proposing to expand the scheme to facilitate persons from other places, including mainland China, to participate in arbitral proceedings in Hong Kong. We aim to announce the details in the near future. Coupled with a gradual relaxation in COVID measures, we are confident that the attractiveness of Hong Kong to be chosen as an arbitral seat will be further enhanced. On the other hand, the government sees that Hong Kong needs homegrown maritime lawyers to provide maritime legal services and will launch a maritime services traineeship scheme next year to provide traineeship for young people who aspire to develop a career in maritime law. Looking forward and following the successful completion of the Hong Kong Legal Week 2022 just a couple of weeks ago, more promotional events will be held to further promote arbitration in Hong Kong. Just to name a couple, in May 2024, the biannual ICCA Congress, which is commonly known as the largest regular international arbitration conference in the world, will be hosted in Hong Kong. The successful bidding of this event is a vote of confidence in Hong Kong's thriving position as a legal and dispute resolution hub. There's also the Fifth East Moot competition scheduled for March next year. This competition is the sister competition to the William C. Fifth International Commercial Arbitration in Vienna, but with an Asian context. It is now an annual event hosted in Hong Kong with the aim of promoting the use of arbitration in international commercial disputes and to nurture talents, including new generations of lawyers and arbitrators. So for advocacy and moot lovers, this is an event not to be missed. At the same time, we are also planning to reach out proactively to other jurisdictions starting from 2023. For example, through the government's professionals participation subsidy programs, we will be jointly organizing an event in Tokyo, Japan, with the Hong Kong Economic and Trade Offices. We will in particular highlight our maritime arbitration and online dispute resolution services. We will also be leading local delegations comprising legal professionals to visit ASEAN member states, other Southeast Asia, the Middle East, and African countries, as well as other common law jurisdictions to promote our legal and dispute resolution services. So I hope to see you all again very soon in upcoming events. On this note, may I wish today's mock session every success. Thank you very much.
Thank you so much, Clifford and Brad. So now before I hand over the floor to Donald, I would like to, on behalf of the organizer, to give a special thanks to EPIC for the provision of the real-time transcription, which our colleague will put on the screen later. So now, may I invite Mr. Donald Sham, partner of Reed Smith, to moderate the mock arbitration hearing. Thank you.
Thank you, Jintao. Ladies and gentlemen, today's mock arbitration will feature 2 hearing sessions, as mentioned by Clifford. The first hearing is conducted under the terms of the Hong Kong Maritime Arbitration Group. It's about an application by the charterers for a partial final award in which they seek what they argue is overpaid hire. The second hearing is a substantive hearing of an arbitration conducted pursuant to the terms of the China Maritime Arbitration Commission. There are cross-claims involved, and they arise out of delay and damage sustained by the vessel in Ukraine. The 2 sets of arbitral rules, the HKMAC rules and the CMAC rules, can be downloaded online via the QR codes displayed on the screen. As mentioned by Jintao, the hearings are supported by transcription services provided by our colleagues at EPIC, and we thank them very much for the support. For the first hearing, we are extremely privileged to be joined by prominent arbitrators and very, very talented practitioners who are getting ready. The arbitral tribunal is chaired by Ms. Carolyn Thomas, with Mr. Sam Choi and Mr. Nick Luston acting as co-arbitrators. The applicant charterers on this side are represented by Mr. Jensen Chang and Ms. Camelia Tang of Smith Richard Speller LLP, while the respondent owners are jointly represented by Ms. Cindy Cole of Stevenson Harwood and Mr. Nathan Xu of Lau Horton and Wise LLP. Without further ado, I'll hand over the floor to the tribunal members to begin the first hearing once they are ready. Thank you very much.
Welcome to the parties. The introductions have kindly already been made by Donald. So that we don't steal any of your time, can the parties just confirm that the rundown is the claimant makes submissions for 20 minutes, the respondent makes submissions for 20 minutes, and then the claimant replies for 10 minutes. Is that correct? Okay. Then without further ado, I pass the floor to the claimant.
Good afternoon, members of the tribunal. I appear with my co-counsel, Mr. Chang, on behalf of the claimant charterers. Ms. Ko and Mr. Xu appear for the respondent owners. This is the hearing of the charterer's application for a partial final award. The full set of facts has already been provided, and I do not intend to repeat them all in these submissions. I will only highlight the following facts. The vessel Amber was chartered from head owners to owners, the respondent in this matter, in April this year. Owners in turn chartered the vessel to our clients on the 10th of June. During discharge of the cargo on or around the 24th of July, the vessel sustained contact damage caused by the stevedore's negligent operation of the shore cranes. The vessel was then redelivered to owners on the 11th of August. At the time of redelivery, charterers had made advance payment of hire in excess in a sum of $350,000 odd. The stevedore damage was repaired by head owners in Singapore. The total cost of repairs was quantified by head owners to be $210,000. Owners withheld the sum of $210,000, the outstanding overpaid hire, and remitted the remainder of the overpaid hire to charterers. Charterers thereafter have commenced arbitration for the outstanding overpaid hire, and this is the hearing of the charterer's application for a partial final award for the outstanding overpaid hire. The tribunal has already received the parties' written submissions, so I'm not going to repeat all of it. So there's no dispute that charterers had overpaid hire to owners. There's no dispute that the stevedore damage had occurred. The dispute between the parties is whether owners are entitled to an equitable set-off. In determining this, we have to consider the test laid out by Lord Denning in the Court of Appeal judgment of the Nanfrey, namely that it is not every cross-claim which can be deducted. It is only cross-claims that arise out of the same transaction or are closely connected with it. And it is only cross-claims so closely connected with the plaintiff's demands that it would be manifestly unjust to allow him to enforce payment without taking into account the cross-claim. This is essentially a two-stage test requiring a close connection between owner's stevedore damage claim and the charter's claim for the outstanding overpaid hire. And two, it will not be manifestly unjust for charterers to enforce payment of outstanding overpaid hire without taking into account the stevedore damage claim. Looking at the close connection, firstly, the underlying subject matters in a claim for overpaid hire and in the stevedore damage claim are entirely different. The former relates to the repayment or return of hire, freight, the contractual price for the service of carriage by sea, which is subject to the freight rule. And for the doctrine of equitable set-off to apply, there must be some equity, some ground for equitable intervention, other than the mere existence of a cross-claim. To put it another way, the claim of overpaid hire concerns charterers' obligation to make payment for the service of carriage by owners, and owners' obligation to return such payment in excess to charterers. The latter concerns the charterer's responsibility for the damage caused by the stevedores with regard to the vessel or her fittings, that is, the physical aspects of the vessel, and has nothing to do with the service of carriage or the hire, freight payable and or returnable under the charter party. Secondly, there is a difference in how the liabilities for payment of the overpaid hire and the stevedore damage arise. Under Clause 5 of the charter party, the overpaid hire is repayable by owners to charterers upon redelivery. In other words, once the vessel has been redelivered, charterer's obligation to repay the overpaid hire, being an ascertained sum or a sum which is readily ascertainable, would arise. By contrast, while the cost of repairs of the stevedore damage have been quantified by head owners to be $210,000, this amount is by no means final and binding on charterers under the charter party and or owners under the head charter. The cost of repairs incurred by head owners will almost certainly be subject to challenge on grounds including but not limited to necessity and reasonableness after consideration of the particulars of repairs. Expert evidence may even be required to opine on the reasonableness and the quantum of such repairs, given the repairs for which charterers are liable are the ones for restoration of the seaworthiness of the vessel. The liability and amount of the stevedore damage can only be ascertained after examining the relevant evidence.
Ms. Tang, if we just go back one step, I'm not sure if your colleague is going to deal, if your colleague is going to deal with this point, but if we go to the issue about the tribunal's power to make a final partial award, the first question I have is why we are here today. Why aren't we dealing with this all in one go at the conclusion of the arbitration? Is that a matter which will be addressed?
Yeah, so Mr. Chang will address it after this.
Okay. Perhaps we'll deal with it at that stage. Can I then, if we're looking at the question of set-off,
Yeah.
if we look at what the owners have said, what is your position about what needs to be established? Because are we actually making a decision today on whether they're entitled to equitable set-off? Are we just simply looking at the question of whether it's arguable? What is the role of the tribunal today in considering your submissions? If perhaps I can take you to your submissions, where you say, in the event the tribunal's of view that the stevedore damage claim may potentially give rise to equitable set-off, it is submitted that such a cross-claim does not give rise to owner's right to retain the outstanding overpaid hire, notwithstanding charterer's claim for the same. So I suppose my question is, do we have to reach a final conclusion that it does give rise to an equitable set-off today? Is that your submission? Or is that for a matter for another day?
So our submissions is that if, so it's for the tribunal today to find whether there is equitable set-off. If there is an equitable set-off, then Charter's application for a partial final award will fail because that is a defense to Charter's application, current application.
Okay.
So, does that?
Yes, thank you.
Okay. Yes, so going back, so owner's stevedore damage claim has not been proven, and the current hearing is not the forum to do so. Owner's position is that charters have breached the charter party by not repairing the vessel prior to redelivery, and that it is on this basis that owners are entitled to hold on to the outstanding overpaid hire as security for the stevedore damage claim. Let's not forget that owners themselves are also in breach of the charter party by holding on to the outstanding overpaid hire. The parties had agreed under Clause 5 that any difference that is in hire due and hire already paid will either be refunded by the owners or paid by the charters, as the case may be. Does that mean that charters are now also entitled to obtain security from owners because of owners' breach? I'll now pass on to Mr. Chang.
Thank you, Ms. Tan. Members of the tribunal, once the tribunal has accepted that the stevedore damage claim of owners has no bearing on our client's claim for the outstanding overpaid hire, the next issue before the tribunal is whether to grant a partial final award in our client's favor, and if so, whether conditions should be imposed. There is no dispute between the parties that the tribunal has jurisdiction and powers to grant a partial final award. The question then is for the tribunal to decide whether or not to exercise its discretion in so doing. The principle is this: the determination of a particular issue at a preliminary stage may be appropriate if it will save time and costs, or it will likely be decisive of a significant part of that dispute. At the same time, the tribunal should consider whether the making of a partial final award will cause prejudice to either party. In other words, the tribunal should look at this matter from a practical perspective with a view to achieving efficiency of resolution of disputes between the parties and to ensure that no injustice or prejudice will be done to the parties. May I know if the tribunal has a question?
All right. I think first of all, can I ask, is this charter concern that owner will dissipate the overpayment?
It is not a current concern because there is simply no basis for us for charterers to allege that owners will have they have raised an argument that charterers are normally asset light and has a high cash turnover. And based on this argument, they're alleging that if the tribunal is minded to grant a partial final award today, charterers will have no incentive to carry on these proceedings in a timely and efficient manner. And they have also made allegation that if the charterers dissipate assets, they will effectively become an unsecured creditor of the charterers. But members of the tribunal, I draw your attention to the fact that owners themselves are also charterers. there are charterers under a head charter party, and they are simply subchartering the vessel to our clients. So in this sense, if there is allegation against our clients for potential dissipation of assets, the same can be said for the owners. And this is something that the tribunal ought to take into account when considering whether or not to grant the partial final award.
If I could ask one more question.
Yes.
You say that one of the reasons to grant the final partial award is to save time and costs and the efficiency, but the reality is that we're having two hearings, in effect, in this arbitration rather than one.
Yes.
If this is a straightforward claim, couldn't this just be dealt with at that final hearing? Everything be handled on one occasion? Why do we need two hearings for this?
Thank you. The reason is that no partial final award is granted today. Charterers will suffer severe injustice and prejudice. This is because once the tribunal has accepted that owners' stevedore damage claim has no impact whatsoever on our client's claim for outstanding overpaid hire, our client's entitlement to that amount under the charter party has effectively crystallized. They have no defense to our client's claim. By reason of the charterer's entitlement to that amount, a failure to return that sum to charterers at this stage will deprive our clients of the use value of that amount. And as my friends have pointed out, charterers are in need of cash because there is a constant need for cash in order to operate their business. So any deprivation from our client of the usage of money to which they're contractually entitled to under the charter party constitutes great prejudice to the charterers. So this is exactly the reason why we submit that the tribunal should make a partial final award now instead of dealing it together with owner's claim for stevedore damage at a subsequent stage.
I have another question. Yeah. It seems that you're talking about interim injunctions by owners, isn't it?
Yes.
And you said that in the absence of any party application, the tribunal has no power to grant interim measures, correct?
Indeed.
And it seems that owner has not applied for any interim measure, correct?
Correct.
So that part should be irrelevant, isn't it?
Owners have not made any formal application for interim measures or injunction. But as the tribunal may have noted from their written submissions, they have asked the tribunal that if the tribunal is minded to grant a partial final award today, conditions should be imposed. And the conditions proposed by the owners include the putting up of security by charterers and also the payment into escrow pending the resolution of the stevedore damage claim. This, in my submission, effectively constitutes an asset freezing measure. And without any formal application brought by the owners, we say that it is an abuse of process
and the tribunal should not accede to such a request in the absence of any formal application and any explanation for so doing.
Could the claimant please clarify, are you saying that the owners have in fact made an application for an interim measure? Are you saying they de facto have done that?
Yes, by proposing to impose conditions, inviting the tribunal to impose conditions to the making of the partial final award. And it is also charterist, the claimant's submissions, that the tribunal has no jurisdiction under the Hong Kong Arbitration Ordinance to impose any condition when making an interim award.
Could you please elaborate on that point?
Yes, precisely. Members of the tribunal, the owners have cited two English case authorities in support of their contention that conditions can be imposed to the making of a partial final award. And those cases are the angelic grace and the trade fortitude. In the angelic grace, the English Court of Appeal made reference to Section 14 of the Arbitration Act in 1950. That section provided that the arbitrator may, if he thinks fit, make an interim award. And the court ruled that that wording, if he thinks fit, enabled the arbitrators to impose any proper condition which they thought fit on the making of any interim award, and it was within their jurisdiction to do so. Later, in the trade fortitude, the English court referred to Section 14 of the Arbitration Act 1979, which essentially adopted Section 14 of Arbitration Act 1950. So the magic wording of if he thinks fit is still there. And in that decision, the judge commented that there's no reason why arbitrators should not, quote unquote, if they think fit, make it a condition of the issue of an interim award that the owner must provide reasonable security for the charterer's cross-claims. So it is apparent from the wording of that decision that the judge had in his mind the wording of Section 14. So based on the authorities cited by the owners, the power of an arbitrator to impose conditions to the making of an interim award originates from the wording of the statutory provisions applicable in England and Wales.
Sorry, my question then is, if you go to, because you've relied on, is it Section 71 of the Arbitration Ordinance as the power to grant the partial award, and that doesn't seem to be in dispute between the parties. What is the difference with the wording of that provision in the Hong Kong legislation compared to the English legislation? Because it seems to me it's a very general provision, just as the English provision is very general in its effect.
Yes. My submission is that in the absence of if he thinks fit, or if they think fit, the magic wording in the statutory provision, upon which the English court seemed to rely on in rendering their decisions in both in the said cases, there is a lack of power on the tribunal in the tribunal when making interim award. Oh, and excuse me.
Yeah, continue, please.
Thank you. And it is our further submission that although the textbooks cited by the owners made reference to these older cases and concluded that the power to impose conditions to the making of interim award under Section 47, subsection 1 of the Arbitration Act 1996 still exists. Well, for the tribunal's reference, that section, the wording of that section is almost identical to Section 71 of the Hong Kong Arbitration Ordinance. It is my submission that this reference in the textbook essentially relies on the jurisprudence of the English courts developed based on the wording of older arbitration acts. So in our view, it is not applicable to the situation in Hong Kong, and it is submitted that tribunals should not follow these English court decisions.
I thank the claimant. You've had your 20 minutes. In fact, you've had slightly more than that, so I will accord the respondent similarly a couple more minutes.
May it please the tribunal, my name is Cindy Koh, and together with my co-counsel, Mr. Nathan Su, we appear today on behalf of owners of the vessel Amber. And we are here before the tribunal today on Charter's application for a partial final award in respect of what they have termed outstanding overpaid hire. Members of the tribunal have heard their application, which proceeds on the basis that 1, Charter's claim is for alleged outstanding overpaid hire, and 2, the alleged claim is not subject to an equitable set-off against the stevedore damage claim, as the two are not closely connected. Before I address the tribunal on owners' positions in response to each of this, I just want to take a few steps back and highlight a couple of points. So, first, I think I want us all to understand how we came to this current situation, how owners and charterers ended up in an arbitration with alleged overpaid hire on one side and stevedore damage claim on the other. Just to point out that there are no other issues in this arbitration apart from these two claims. And maybe just to put it another way, why is there even the stevedore damage claim at all? Charterers will not deny, and they have no basis to deny, that the stevedore damage occurred, that they are liable for the stevedore damage, and they didn't comply with their obligations under the charter party to conduct the repairs. And so the reason we have this stevedore damage claim today is because charterers failed to comply with their obligations under the charter party. And all they dispute is quantum of the claim, which they say falls to be ascertained, it's being passed down by head owners, which actually we say all of this is caused by the fact that they didn't conduct the repairs themselves. So I urge the members of the tribunal to remember that the reason we are here today is because charterers failed to conduct the repairs in accordance with their obligations under the charter party. So now we understand why we are here today. Then we look at what we are dealing with today. And what we are dealing with today is an application by the charterers for a partial final award. And what does that mean? It means that charterers are essentially asserting that their claim should be determined before owners' claim. And because this is an application for a partial final award, the tribunal has absolute discretion whether to grant it or not and on what conditions. And this absolute discretion is not being disputed by the charterers. In exercising the discretion, I think one key issue that has come up between the parties in the submissions is whether the tribunal is entitled to consider whether there are other closely connected claims with the claim for which the partial final award is sought, and whether the existence of that other claim that may be set off means the tribunal should be slow to make a decision on one while disregarding the other. On this, it is first common ground that there is another claim in the arbitration, and this is owner's stevedore damage claim. But what is in dispute is whether this claim is so closely connected that equitable set-off may apply. And at the stage of the partial final award application, we want to make it very clear that owners are not asking the tribunal to make a final determination on their claim. And indeed, the standard of proof on owners today is to show that owners have a claim that is 1, advanced on good faith, and that 2, on reasonable grounds, it gives rise to equitable set-off against the claim. So to this extent, I object to the position that my learned friend made to say that the tribunal must find today whether there is equitable set-off or not. So even if the tribunal cannot come to a firm conclusion on whether equitable set-off applies, so long as the tribunal is persuaded that there are reasonable grounds for an equitable set-off, then we say that the tribunal should exercise its discretion not to grant the partial final award application. And that will not put charterers in any worse position, really, because parties will then proceed with the arbitration and have both claims determined at the same time. And owners have already indicated that we are prepared to proceed with the claim on an expedited basis. So against the background of these two main points, owners today will demonstrate to the tribunal that the tribunal should exercise its discretion to decline to grant this partial final award because, one, the nature of the charterer's claim is not straightforward and not suitable for determination by way of a partial final award. Two, owners have a reasonable ground to exercise an equitable set-off of the stevedore damage claim against the outstanding overpaid hire claim, and that there is no prejudice to charterers in having both claims determined together, or if the tribunal is minded to grant this application, then conditions should be imposed. I will address the first two issues regarding the nature of the charterer's claim and equitable set-off, and my colleague Nathan will then address the tribunal on the remaining 2 points.
Is subject to the issue of equitable set-off, is there any dispute about the overpaid hire of $210,000 US? Is it accepted if we put to one side the stevedore damage claim? Is that sum due and payable?
When we use the term due and payable, I think I must object to that, because while the terms of the charter party provide that any excess amount that's paid must be refunded, it does not, in the wording of the charter party, say that it must be refunded within a certain number of days after the charter party is concluded, for example. So I would not consider it as a debt that is due and owing.
Sorry, but perhaps I've misworded it. Is there's no dispute regarding the quantum, or that there has been an overpayment of $210,000 US subject to the set-off claim?
As a matter of accounting, yes, we agree that there is $210,000 that is in dispute between the parties, although we object to the label that has been attached to it as being overpaid hire. And I will explain that in the next section of my submissions. So, as I indicated, owners take issue with the nature of charterer's claim, and we submit that it is not suitable for determination as a separate issue. Owners submit that charterers have artificially framed their claim as outstanding overpaid hire, which is misleading and calculated. Such a label disregards the circumstances in which parties arrived in this current accounting position. In the usual charter party transaction, there may be overpaid hire as a matter of accounting at the end of a charter party. And if it is that usual situation, yes, charterers have good reason to ask that their monies be returned to them. And this is the usual situation that is in the case that is cited by charterers. But in this case, it is different. Charterers have put themselves in the illusion of this position of having overpaid, when in fact, this current accounting position arose because of their own failure to comply with their obligations under the charter party. The background facts have been explained by the charterers, and we have highlighted some other key facts at paragraph 12 of our submissions, and I will not repeat them. But in essence, charterers knew about the stevedore damage, were notified immediately. They do not deny it happened, they do not deny it's their responsibility, and they also do not deny that they re-delivered the vessel without performing the repairs that they should have done. So charterers effectively created this current situation, and then now they conveniently turn around to make this partial final award application by isolating a claim for outstanding overpaid hire and ask for it to be determined first.
Ms. Goh, can I interrupt a bit? Have disposal owners paid the stevedore damage to head owners?
I believe it's not part of the statement of facts here. Disposal owners have not paid it to head owners, but head owners have already tabled this claim to disposal owners, which disposal owners have then passed down to charterers in this arbitration.
So you have not paid the head owners?
It is also the subject of a determination in separate arbitration.
I see.
So, just to explain again, a partial final award application is not appropriate for a claim that is not straightforward And neither is it appropriate if it does not achieve fairness for the claim to be determined first. And we submit that having regard to the true nature of the circumstances leading up to this application, Chartered's claim cannot be seen as simple and straightforward, outstanding overpaid hire, and should not be determined by way of a partial final award. So I now move on to deal with our second argument that the tribunal should decline to grant the partial final award because owners have a closely connected claim on which we can rely on equitable set-off to set off against Chartered's alleged claim. Charterers do not appear to dispute the relevance of equitable set-off. Instead, what they contend is that equitable set-off does not apply here because the two claims are not closely connected. And I will take this opportunity to remind the tribunal again that the applicable test at this stage is not to determine conclusively if equitable set-off applies, and also not to determine conclusively if $210,000 is what we are entitled to under the stevedore damage claim. What I need to demonstrate to the tribunal today is that on reasonable grounds, there is a right of equitable set-off. And then that would suffice for the tribunal to take that into account when exercising your discretion. And for this, I rely on the case of the Costas Melas, which is at paragraph 22 of my submissions, and also in the owner's bundle of authorities. The case deals with an interim award, but we say A fortiori will also apply to an application for a partial final award, where the court said that where a respondent has a counterclaim which is advanced in good faith and is set on reasonable grounds to give rise to an equitable set-off against the claim, an interim award should either not be made or should only be made for the net amount of the claim. So, the test is therefore, 1, whether there is a counterclaim that is advanced in good faith, and 2, whether on reasonable grounds it gives rise to an equitable set-off against the claim. In this case, I don't think Charterers seriously dispute that the counterclaim is advanced in good faith, not least because they don't deny the stevedore damage, they don't deny the claim, but only the quantum of it. So I will address the tribunal on why owners say that on reasonable grounds, the stevedore damage claim gives rise to equitable set-off. This is at paragraph 27 onwards in the owner's submissions, but in short, owners submit that the overpaid hire and stevedore damage claim are closely connected because they arose out of the charter party relationship and flow from performance of the charter party. And we rely on the authority of the BIM Chemi case and Blackburn Chemicals, where the English Court of Appeal said that while equitable set-off requires inseparable connection between the claim and the counterclaim, it is not necessary that they arise out of the same contract, and all that is required is that it should flow from the dealings and transaction which gave rise to the subject of the claim. In this regard, Charterers have raised two arguments as to why the claims are not closely connected. The first, that the underlying subject matters are different, and the second, that the liabilities are different. I will deal with each of these to explain why these arguments are misconceived.
This issue with equitable set-off, the Charterers have referred to a case of Esso Petroleum and said that it may even be the case if the claim and the counterclaim arise out of the same contract, that would not be sufficient to give rise to an equitable set-off. What do you say to that?
Sure. To deal with this case on Esso Petroleum, I think, first of all, members of the tribunal will have seen from our submissions that we take issue with their misquoting of the case. And if I can just explain the circumstances of that case in which the principle of equitable set-off was considered, there were two bases on which the court considered whether equitable set-off should apply in that case. The first, of course, is what we have been discussing, which is whether there is a sufficient or insufficient connection between the two claims. And in that case in particular, there was one more ground on which the court considered whether equitable set-off should apply, and that the court labelled the direct debit argument in that case. And that's because the nature of that claim in that case is somewhat special. And because of the special nature of that claim, the court would take into account those circumstances as part of the equitable set-off argument. And these are the circumstances, which is that the main claim is a claim for supplies of petrol that is made by the plaintiff. Pursuant to the contract, the defendant had agreed to pay for this by way of direct debit. So the court said that, okay, because you have agreed to pay this by way of direct debit on or before delivery, they said, well, this is not exactly the same as a claim under a check for which you cannot assert equitable set-off. This is quite a compelling circumstances to consider whether such a claim should be subject to equitable set-off or not. And one further factor they took into account was that these sales or these supplies of petrol that were made were converted to cash immediately when they were sold. So because of these special circumstances of the claim, it gave rise to another basis for the court to consider whether equitable set-off should be disapplied, quite apart from the usual insufficient connection. And I would say that all of that has nothing to do with this case. So
what is the difference in this case? Why is that case distinguishable in these circumstances?
because in the ESSO case, the particular difference in the nature of that claim is that, one, the claim is for goods that have been supplied pursuant to a contract that expressly says you must pay on or before delivery by direct debit. Not just you have to pay for the service, not just that you have to pay for the petrol, you have to pay for it on or before delivery and by direct debit. And also that once it is supplied to you, you will be able to convert this into cash. So taking all of these three things into account, the court seemed to suggest that the nature of this claim is a little bit different from a usual just claim for unpaid goods. And because of these special circumstances, the court said that maybe equitable set-off should not apply to a claim like this.
So can you explain then what in our case is different?
I think in our case, what the charterers have claimed for, they have said alleged outstanding hire. First of all, it's not something that has to be paid to them by a certain number of days. As I've pointed out, the charter party does not say that. Second, it is also not that owners have had any particular use of this money except having received it in the ordinary course of the charter party. We didn't use this money to gain further income. This same money that was paid to us was paid upwards on hire. So for this reason, I would say that the facts of this Esso Petroleum case are actually particular, and the additional basis for which the court considered whether equitable set-off should apply in that case is particular to its facts, and I would say doesn't apply to our case. So just coming back to my...
Given the time allowed, I would like to jump to the part belonging to Mr. Choi. Yeah. Can I ask him about you asked for condition being imposed if we are mind to grant the partial final award, okay? I have two questions to you. One is, given what Mr. Lechton said about Section 71 of the Arbitration Ordinance, can you elaborate why we have the power to impose the conditions? This is my first question. The second question is, even if we are against you or for you, that means whether we grant the final partial award or not, is it still the case that we have the power? Because you said that if we are mind to grant the final partial award, you ask for a condition, okay? How about if we do not grant the final partial award? Do you accept that we still have the power to grant the conditions, to impose the condition as set out in paragraph 51 of your submission?
Thank you, member of the tribunal. In terms of Section 71 of the ordinance, we rely on primarily the trade fortitude and the angelic glory. As Mr. Cheng from the claimant has mentioned, he sought to suggest that this power has evolved or kind of been restricted between the 1950 Arbitration Act and the 1996 Arbitration Act. With respect, we simply don't agree with that proposition. It's difficult to argue with three prominent textbooks which all point to the fact that the trade fortitude and the angelic glory continue to apply to English law. And insofar as they apply to English law, they must also apply, because the provisions in English law and Hong Kong law are peri materie, so the English provisions, we should be able to rely on those in determining to what extent the tribunal has powers to impose conditions when granting partial final awards or any kind of interim award in that sense. So I believe the tribunal's first question is, where is the power and does the tribunal have the power to do so? We say the answer is yes. And we do not think the words "if he thinks fit" in the 1950 Act really changes too much. All the textbooks agree that the power, if anything, has widened, not been restricted since the 1996 Act.
So how if we say we dismiss the charterer's application? Do you think that we still have the power to ask you to do what you suggest in paragraph 51?
Well, thank you. I think that would depend on what form of what form that order would come from. We would respectfully submit that, in the sense that a interim award is being granted, as the claimant is applying for one, then conditions can be imposed. But if the tribunal is not minded to grant any award at this stage, then there's no basis on which to include conditions, and certainly it's not something the claimants have asked for. So I think that question might not be relevant at this stage. It's not something we.
Well, I will give try to reply later on.
Charterers actually rhetorically asked if charterers are now entitled to security from owners in this situation. So would charterers have the parties discussed an escrow agreement, and do you think that charterers are now entitled to security from owners?
Well, I think first and foremost, the point about security is interesting, because what we have is charterers, as Mr. Cheng has alluded to, are typically asset-light companies. They typically have a bank account, but we don't mean to generalize. But
they pointed out that you are disponent owners.
Yes, so the same applies to us, really. And at the present stage, we have the cash flow advantage, in the sense that we hold on to the money, and if they succeed, then we pay it to them. There's just simply no reason for that to change. That is the status quo, and that is the case when the vessel was redelivered. That is the case when arbitration was commenced, and they're now trying to seek to change the balance. And we would say that that's just an injustice on our part.
Now, the word status quo is interesting because it comes up in applications for interim measures, obviously. And when I asked charterers whether owners had made an application for an interim measure, they said de facto yes. Have you made an application for an interim measure?
No, we certainly don't hold ourselves as making an application in this sense. We think that the power to ask for and be granted conditions comes from the cases such as the angelic grace and the trade fortitude. In those circumstances, we don't think the court was considering it to be an application for an interim measure, so to speak. And insofar as conditions are being placed, that I think is completely separate to asking for, say, injunctive relief.
In paragraph 49 and 51, you've outlined three alternatives as what could occur in terms of imposing conditions. Could you please address the tribunal on which of those, if we were minded to impose, to grant a partial award and to impose conditions, which of those three conditions would you suggest?
Well, I think the first condition we always refer to is for charterers to provide security, because that is the one that has been referred to in the cases that we've cited. I think the more direct method would be for owners to perhaps provide, to pay the alleged outstanding overpaid hire into escrow. That seems to just require one payment rather than they put money in, we pay money to them. In terms of escrow agreement, the terms of an escrow agreement, whether that's been negotiated, I think certainly the tribunal is able to make an order saying that the parties can, the tribunal can reserve its powers to make an award on the terms of the escrow agreement, but the parties can certainly try and negotiate the terms first.
Thank you. I think it's for charterers to now reply.
Yes, and we'll try to keep it short. To address my friend's submissions on the imposition of conditions, first of all, to invite the tribunal to order a payment into escrow as a condition of making the partial final award would effectively be depriving charterers from what they're entitled to under the charter party. And if the tribunal is minded to take the alternative of requesting the charterers to put up security, this is effectively allowing owners to gain from their own breach of the charter party by failing to return the overpaid amount to charterers.
So, Mr. Chan, there are possibly there are two options open to us. Okay.
Yes.
I'm not saying that we have made up our mind. Okay.
Understood.
We can either dismiss your application or ask money to put into escrow account. So are you saying that you want to dismiss our application and then don't ask the money put into our escrow account?
Mr. Chair, currently we do not have instruction from our clients to suggest this is a feasible option. But on a subject to instruction basis, if the tribunal is faced with the alternative of either dismissing the application or allowing the application, but on the condition that the payment be ordered to be made into escrow, it is my submission that this would be accepted by the owners, provided that the tribunal is satisfied as to its jurisdiction, its powers to impose conditions as to the making of interim award.
Just going back to the question of powers, because it's something which I raised earlier, and you've heard the submissions from owners. And their submission is, in fact, that the legislation has broadened the powers, if anything. What do you say to that? Why do you say it's actually narrowed the powers? That the 1996 legislation actually acted to reduce the powers, and the ordinance, because it's said that the wording is similar. I don't have the wording in front of me, but why do you say it's narrowed now?
Well, it's not about narrowing down or expanding the scope. It's more about whether the English jurisprudence on the power of arbitrators to impose conditions is equally applicable in Hong Kong, because there's no suggestion that a tribunal under Hong Kong law has the power to impose condition when they're making partial final award. And this is in contrast with the English position, which cases relied on the wording of the previous Arbitration Act in developing its own jurisprudence. So we are saying that there's a difference between the two jurisdictions, and the tribunal should not follow the English jurisdiction and should focus on the wording of the Hong Kong Arbitration Ordinance.
Respectfully, owners have put a copy of the Arbitration Act in their submissions, and it's also much briefer than the previous version. So if you're right then English law would have changed and all the textbooks are wrong. Is that your submission?
We have no further submissions in this regard. Thank you.
Can you respond to owner's submission on the Costa-Malles case? About what they said, that they do not need to show equitable set-off as long as there is a reasonable case to argue, and then etc. Okay.
We say that this suggestion is neither here nor there, because first and foremost, we submit that the stevedore damage claim is incapable of operating as equitable set-off. So even if their submission on the law is correct, it doesn't mean that what they have asserted is an equitable set-off which has any bearing on the charterer's claim for outstanding overpaid hire.
Do you have any further submissions, or are we now ready for the tribunal to discuss?
Just one more point.
Okay, you have 1 minute.
Yes. Thank you. My friends mentioned that there is an ongoing stevedore damage claim as between them as disponent owners and the head charterers. And it appears that the liability and the quantum thereof has not been decided, and it's still disputed. So in this sense, as submitted by Ms. Tang, stevedore damage arose from the damage done to the fittings and the physical aspects of the vessel, whereas the hire was paid in relation to the carriage and the service for hiring the vessel. So they're fundamentally different. So it brings to our conclusion that there cannot be any equitable set-off. And so the tribunal is invited to grant a partial final award in the claimant's favor. This is the end of our submissions.
Okay. What do we think about the equitable set-off point? The parties seem to agree that we have jurisdiction to grant a partial final award. So what do we think first about equitable set-off?
I think we are, at least on my part, I'm impressed by the Costa-Malles case. I will follow that line of reasoning. I don't need a clear-cut answer as to whether there is an equitable set-off. As long as owner can show counterclaim in good faith and is set on reasonable ground to give rise to an equitable set-off against the claims, then on that part, I intend to follow the arguments of owners. Yeah.
So then owners would win, the application would be defeated?
Then we consider the condition, whether we need to impose some condition, even if we actually dismiss the application.
Oh, I see. What do you think, Nick?
I would personally take the view that I appreciate the authorities on that point, but I have some question marks as to whether there is an equitable set-off. My conclusion would be that a condition be imposed that the money be paid into escrow for the partial final award, because that would also avoid what is inevitably here a position with either side saying that someone's holding the funds, and it simply is then held pending the determination of the stevedore damage claim.
I think I'm more inclined to be with Nick, but my problem is so many Charter Party claims are big bags of claims after it's ended. And if charterers were right, the moment you accept, then you'd get a partial final award. And that would make it very undesirable to admit anything. But my instinct was, let's go to escrow. So on balance, I think you're basically saying, allow it, but impose conditions of escrow, and you're saying the same thing on balance?
Yeah.
I agree on balance, and Sam had a very good point, which I think underlines that we are arbitrating under the HK-MAG rules,
Yeah.
and I leave it, I'll give you the one that works.
Since we are members of HK-MAG, actually we have a procedure whereby money can put into escrow account, and HK-MAG provide a very affordable fees as 5,000 Hong Kong dollar for fund holding services. So given the decision of chair just allowing to you, we will actually encourage people, or if you cannot agree on the terms, we can put in the terms that the money be put into, the overpayment hire to put into account of HK-MAG, pending the final resolution of the matters.
Thank you very much. I believe you've heard our decision.
Thank you very much for the arbitrators and council team for their very excellent performance. I just want to mention one point. If anyone in the audience expect to be able to hear the tribunal's deliberation in real life, and together with some advertisement done for HK-MAG, then you'll be disappointed it doesn't happen in real life. They will usually retire in a breakout room and do the deliberation. And in most circumstances, in real life, they will not deliver an oral ruling. They will reserve the decision, which will be issued in writing later on. So it's an absolute privilege to be able to hear that for the first time in my life. So thank you so much. We shall now begin the second mock arbitration hearing. But before that, I'm just wondering if the audience has any questions for the arbitrators of council in respect of this scenario. I think we can maximum take one question because the time is running out. If not, then we'll proceed to the second hearing. May I ask the arbitrators and counsel for the second scenario to be seated on the stage?
Welcome to this mock Hong Kong arbitration of disputes under a time charter party between owner Atif and charterers Smooth Sailing. By way of introduction, my name's Bill Amos, and I'm the presiding arbitrator of this tribunal of three. My co-arbitrators on the panel are Miss Nicola Mason and Mr. Jagmeet Makar. Representing the claimant owners are Mr. Pryderi Diebschlag and Miss Cindy Yeung of Clyde & Co. The respondent charterers are represented by Miss Maggie Lee and Miss Coco Zheng of Hai Wan and Partners. For this afternoon's hearing, we have a duration of just 1 hour, so time is short. I understand the parties have agreed a timetable for their oral submissions, so I'd urge you to keep to your very short allotted times. You will have noticed that there are no witnesses. That suggests that the facts are agreed, or largely agreed, as we may find out. With that, Mr. Diebschlag, I believe you're going for, with that, Ms. Yeung, I invite you to open the case for the claimant ship owner.
Thank you. Members of the tribunal audience, I'm here with me, Mr. Prideri Divshak, as counsel for the claimant, Mr. Atif, and my learned friend, Ms. Coco Jiang, and Ms. Maggie Lee, are counsel for Smooth Sailing Limited, the respondent. And as mentioned, today's substantive hearing is in respect of a time charter party entered into between my client as owners of the vessel Invincible and the respondent as charterers. I believe the tribunal has before you a set of documents containing the statement of facts, which are largely agreed, and also an extract of the key clauses of the charter party annexed. The parties have also submitted their written opening and reply submission, and also a bundle of authorities referred to therein. And before I start, I wish to clarify that the parties have agreed on the time allocation for the submission, and because the claimant is going to cover the factual scenario, we are going to have 23 minutes, and the respondent will have 17 minutes for the reply. And for the 10 minutes for the reply submission, we'll equally share 5 minutes each. So I'll first briefly recap on the key facts. And to assist the tribunal, we have prepared some slides showing a timeline of the major events. I have here with me some hard copies. And as you can see, the timeline shows major events, which is prepared based on the statement of facts and also information publicly available. On the second page of the slide, as you can see, on the 22nd of January, pursuant to the charter party, my client duly delivered the vessel to the respondent at Santos in Brazil. The respondent then issued orders for the vessel to sail to Mariupol, which is in Ukraine, to load a cargo of wheat by the 22nd of February. But 3 days later, as you can see from the timeline, on the 25th of January, after the vessel set sail from Brazil, Russia has already conducted military exercise near Ukraine. And 2 days later, the White House issued warning that Ukraine may face an imminent invasion by Russia. And by the 10th of February, Russia has already begun military maneuvers. And 1 day later, many countries called upon their citizens to leave Ukraine. This includes the White House instructing Americans to leave the area within 48 hours, and also the UK Defense Secretary saying that an invasion may take place at any time. Now on the second page, we see that on the 17th of February, fighting has escalated in separatist region of eastern Ukraine. And so on the same day, my client received a letter from the master of the vessel raising safety concerns over the crew in light of the possibility of military escalation in Ukraine. And also they requested the respondent to cancel the order to Mariupol. My client informed the respondent of this letter, but the respondent replied insisting the vessel to load in Mariupol according to the schedule by the 22nd of February. And because of this, the entire crew resigned, and my client had to arrange for replacement crew. And because of the short notice, fresh crew was only available in Spain, and so this required a deviation to Spain. And the vessel only arrived at Mariupol on the 24th of February, which is 2 days later than the original schedule. And by that time, invasion had already begun. And after loading the vessel with the cargo of wheat, it was hit by a Russian missile, which causes damage to the vessel with the hatches being blown open. So on to the next slide. On the 25th of February, repairs of the damage began, and it lasted for 10 days. And afterwards, it was discovered that the wheat was also infested with beetles, and so fumigation was required, which lasts for a further 4 days. And so the vessel finally left the port on the 10th of March and arrived at Jakarta, which is the port of redelivery, on the 14th of April. This is 2 weeks later than the agreed charter period, as the charter period expired on the 30th of March. Now, my client's claim and the respondent counterclaim are set out in paragraph 2 and 3 of the claimant's written opening submission. It is on page 1 of the submission. My client is claiming against the respondent for a total sum of nearly $2.3 million US, which includes cost of repairs, additional wages and war risk premium for the vessel to enter Mariupol, and also hire and damages associated with the late redelivery. The respondent is counterclaiming against my client for losses caused by deviation, a pro rata reduction in hire for late redelivery, and also the devaluation of cargo, which totaled to $1 million US. So from the facts of this case and the parties' claims, 4 main issues have arisen. The first one, whether Mariupol was an unsafe port. Safety is disputed by the respondent. And our case is that Mariupol has become unsafe at the time the news of an imminent invasion of Ukraine broke out. The second issue is whether Mariupol was subject to war risk, which will trigger the application of Clause 14 under the Charter Party. The third issue relates to deviation, whether my client was responsible for the delay, and whether the respondent can rely on the off-hire clause. And finally, on repairs and fumigation, whether my client complied with its obligations for maintenance and cargo. This relates to the respondent's counterclaims. I will deal with the first 2 issues on safe port and war risk, and leave the remaining 2 issues of delay, off-hire, and owner's obligation to my co-counsel. So first on safe port, the definition is laid down in the case of the Eastern City, which is item 1 of the claimant's authorities. It states that a port will not be safe unless, in the relevant period of time, the particular ship can reach it, use it, and return from it in the absence of some abnormal occurrence without being exposed to danger which cannot be avoided by good navigation and seamanship. Although the focus is usually on the ship, risk to the crew can also render a port unsafe. And unsafety also includes the danger created by political situation, as in the case of item 2 of the claimant's authorities, where there was rebellion in the city of the port and the government closed down the port. Charterers are under a primary obligation to order the vessel to a port which is prospectively safe at the time of nomination. But in this case, my client's claim is based on the respondent breach of a secondary obligation, which arises when the port nominated became unsafe when sailing to it. There is an obligation on the charterer to then cancel the original order and to issue a fresh order to a port that is prospectively safe at that time. So in respect of the port in question, Mariupol, geographically it's situated at eastern Ukraine. It is one of the 5 major ports and the port closest to the Russian border. So we say that it is a likely target of attack by the Russian troop, and it is obviously unsafe. Vessels and persons on board may be considered targets, enemies, or terrorists, and they may be detained or attacked. The respondent dispute unsafety of Mariupol, and they allege that the vessel being hit by the Russian missile was unexpected or abnormal. But as the tribunal can see from the timeline, there has been widespread reporting of the imminent invasion, even before the master letter requesting cancellation of the order and the arrival of the vessel at Mariupol on the 24th. Such circumstances make military action a characteristic of Mariupol, and we contend that the threatened and reported imminent invasion in late January, if not by early February, already turned Mariupol into an unsafe port. This triggered the secondary obligation for the respondent to cancel the original order to Mariupol, especially after the express request from my client, and because they refused to do so, we say that they are in breach of the Safe Port Clause. Russia invaded Ukraine on the 24th of February, and on the same day, to perform the respondent order, the vessel arrived at Mariupol and was hit by the missile. And so we say that the damage arose from the respondent order, which was in breach of the Safe Port Clause, and so they are liable for cost of repair, which my client paid in the sum of $1.5 million US. And so now I'll turn to the issue of war risk. The Charter Party adopted the BIMCO War Risk Clause, which is called Wartime 2013. And may I refer the tribunal to Clause 14, subclause A2, in the extract of the Charter Party Clause. here the definition of war risk is given. The respondent dispute application of this clause before the 24th of February when the actual invasion took place. But as you can see, the phrase refers to war risk and not just war alone, and the definition expressly includes threatened or reported war, hostilities, warlike operation, etc. And so we contend that this covers the present scenario before the 24th of February. And in fact, in the respondent authorities at item 10, which was submitted by the Respondent Council earlier this morning, it is an article issued by BIMCO on the 24th of February. And at paragraph 3, may I refer members of the tribunal to that paragraph? It says that war risks do not require declaration of war by states. So it also covers risks of war, potential ones, threatened ones, reported ones in addition to actual war. And we say that by mid-February this year, war was virtually certain between Ukraine and Russia, and that it would take place within days. There's a real and sensible risk of danger. And from the master letter and my client passing on of it to the respondent, it is in the reasonable judgment of master as well as my client that the threatened military action would be dangerous or may become dangerous to the vessel and to the crew on board if the vessel entered into Ukrainian water. We say that Mariupol is subject to war risk before the 24th of February, and so this triggered the application of Clause 14. And under Clause 14, the vessel is not obliged to proceed, and the respondent was in fact requested to cancel the order. They refused, and so the entire crew resigned in fear of their own safety, and my client had no alternative, but they have to employ fresh crew so as to comply with the obligation to provide under the charter party. And this cost my client an additional wages of $86,000. Also, under the coverage terms of my client insurers, they have to pay an additional premium of $118,000 for the vessel to enter Mariupol because it is considered a war risk zone. Under the Clause 14, subclause D and F, my client is therefore entitled to recover the additional premium and also the additional wages paid for the vessel to sail into Mariupol, and these have to be reimbursed to my client by the charterers. I will now pass on to my co-counsel to address the issues on delay. Yes?
Thank you, Ms. Young. If I could just ask a question on your submission. So, owners say that Mariupol was unsafe.
Yes.
Why did owners still go there?
The owners still go there because they treated the respondent's reply as a refusal for the request to cancel the order. And there's a difference between time charterers and voyage charterers in that the time charterers have control of the employment of the vessel. And so we say that, and also under the charter party, the owners are obliged to follow the orders of the respondent.
Thank you.
But even if we deny that the owners accept the respondent order, but even if my client is treated as having accepted the respondent order, we are still entitled to recover damage for the breach of the Safe Port Clause, for any damage sustained by the vessel because of the performance of their order.
Thank you very much. Mr. Deepshag.
Thank you very much, Mr. Presiding Arbitrator. Just to pick up on one point that was just queried, this issue actually came to light in the Kanchenjunga, and it was mentioned therein. I believe this is in your bundle, tab 10, page 400 of that case report. That the owners in that case found themselves in a situation in which they could either reject the charterer's nomination of Karg Island as uncontractual, because it was an unsafe port, or could nevertheless elect to accept the order, load at Karg Island, and thereby waive or abandon their right to reject the nomination, but, and this is important, retaining their right to claim damages from the charterers for breach of contract. And that is where we say owners find themselves now. Now going back to...
Sorry, would you mind if I just asked a question? bearing in mind that case, there was no physical damage in that case, was there, to the vessel?
No, I believe not.
Okay, so if there had been physical damage and it was to be decided by the judges, would they need to consider the issue of reasonableness?
Certainly in terms of the response thereafter from owners as to how they reacted to the damage, and we will come to that momentarily.
What about the reasonableness of then going to a port?
Ultimately, the election has to be made as to whether or not you obey instructions or refuse to perform and take the consequences of doing so. That would then be determined, I suppose, from charterers claiming that a refusal was unreasonable.
Okay. Thank you very much.
Now, I have the rather easy job of walking through a little bit of mathematics. As you have heard, the terms of the charter party provided for the vessel to be hired by charterers from the 22nd of January until the 30th of March. That is clause 1.1 of the charter party. And then pursuant to clause 7, we see the rate of hire is specified to be $40,000 per day pro rata. Now, as a result, and there it is stated that hire was to continue until the time of her redelivery. Now, the vessel was indeed returned to owners in Jakarta on the 14th of April, 14 days after the end of the charter period, which gives rise to owners' claim for hire in the sum of $560,000. Now, in addition, owners claim consequential damages, being the difference between the charter rate as fixed in the charter party and the market rate at that time. The market rate at that time being $42,000, leaving a difference of $2,000 per day. Now, I don't believe the legal principles here to be particularly in question. We are seeking compensatory damages on the basis that owners should be put in the position as if the contract had been performed, i.e. the vessel had been redelivered on the 30th of March. So owners claim for the difference, $28,000 in total for the 14 days. For the sake of completeness, although I believe respondents will turn to it, this falls underneath the second limb of Hadley and Baxendale, which I believe is probably well known to everybody in the room. Now, in diminution of charterers' claims, owners' claims, charterers raise three key arguments. Firstly, they assert that the 2 days of delay was in fact caused by owners' deviation in mid-February. Now, this was done in order to replace the crew, and that rendered the vessel to be off hire, according to charterers' argument. Now, that is due to deficiency or strike of officers or ratings under clause 8 of the charter party. And they say that this will result in a pro rata reduction of $80,000 for the 2 days of deviation. Now, we would make 2 points here. And the first one may be somewhat surprising, but we would assert that this is not a deviation. Now, this point is expressly addressed in clause 14J of the charter party, being the war risks clause that my colleague turned to a moment ago. And in 14J, it specifically states that when acting in accordance with any of the provisions of subclauses B to H of this clause, anything is done or not done, it shall not be deemed a deviation. Now, I would then direct you to 14G subsection 5, wherein the vessel shall have liberty to call at any alternative port to change the crew or any part thereof, where there is reason to believe that they may be subject to internment, imprisonment, detention, or similar measures. Now, of course, it's extremely difficult to know what would have become of the crew from sailing into a war zone, but they were clearly in danger, and we would submit that it was therefore necessary to change the crew for that purpose in addition to their resignation. So we would say that it is not a deviation. Now, if you are not with me as regards the deviation point, and you're with charterers in that regard, charterers' argument does itself rather ignore the fact that the necessity to replace the crew arose because of their own action. their own breach of the safe port clause. And it's trite law, of course, that a person cannot rely upon their own breach of contract or the non-performance of a contract cannot rely on a breach or non-performance if it's brought about by their own action. Now, there is authority, if you wish to refer to it, in tab 5 of the bundle for that, but for present purposes we can skip on. So this is the first point. The second point then is charterers argue that owners' damages should be diminished on account of delays caused by the repairs to the vessel that were required. And this is based on an assertion that an alternative yard was available, and that alternative yard could have conducted the repairs in 5 rather than 10 days. This amounts to a reduction of 200,000 on charterer's case. Now, it should be uncontroversial that owners are responsible for keeping the vessel's hull and machinery and equipment in a good state of repair. This is clause 4 of the charter party. But this is not an absolute requirement. If I could briefly turn you to tab 6 of the bundle, this is the SNIA case. And this is page 88 of this case report. Now here, towards the bottom third of this first column, we see the statement that the owners will maintain her in a thoroughly efficient state of hull and machinery during the service. Now that does not mean that she will be in such a state during every minute of the service. It does mean that when she gets into a condition when she is not thoroughly efficient in hull and machinery, they, meaning owners, will take within a reasonable time, reasonable steps to put her back into that condition. So charterers now cannot complain about delay caused by the repairs, now in part because it is of their own making by directing the vessel to an unsafe port, but also because the question really is whether reasonable steps were taken within a reasonable time. In this case, reasonable steps were taken immediately to effect the repairs. There was no delay, there was no dragging of the feet, and frankly, hindsight is a lovely thing, but it shouldn't be used to question reasonable actions in a time of war. Now, this point is also clearly made in Carver and Charter Parties. Now, this is in tab 4 of the bundle. I'll briefly read you an extract from it, wherein it states at paragraph 7817 that even if there is no express provision or agreement in the charter party, the ship owner is bound and entitled to take the vessel out of service for a reasonable time in order to effect repairs and comply with its maintenance obligations. Does not commit any breach of charter by doing so, and hire continues to be payable unless there is an express off-hire clause covering that situation. Now, there is no express off-hire clause that applies here. The off-hire clause is clause 8 of the charter party, and I expect charterers will focus your attention on the word repair, which appears halfway through the clause. Now, that needs to be read in context, and the context is dry docking for the purpose of examination, cleaning, painting of underwater parts, and or repair, or by any other similar cause preventing the full working of the vessel. Now, these are causes which happen in the ordinary course of the trade, or otherwise as a result of owner's default. That is not applicable in this case. This is not a case where the vessel required anti-fouling treatment. Now, this was considered in the Lena. Now, I apologise for making such use of the bundles, but if I could turn you to tab 9. Here, this is on page 515 of this case report. Now, here the vessel was detained in quarantine and hire continued to run, and charterers asserted that it should in fact be off hire. Now, at the bottom of page 515, the question comes to be, where a vessel is detained in quarantine under such contract, is it debarred from claiming freight during the days of quarantine? Well, there is no clause which declares this in the terms, and it can therefore only be made out by inference, and I am unable to find in the Charter Party anything from which such inference could reasonably be drawn. Now, we say that is the situation that we find ourselves here. The inference does not apply. The inference actually is that you are off hire if there is a fault on the part of owners. That is not the case. Now, the third aspect, and I appreciate I am close on time, so I will be swift. Charterers assert that time was lost to fumigation, and that was a direct consequence of owners' choice of shipyard. Now, this amounts to some 4 days, resulting in a diminution of $160,000. Now, again, there are 2 points to make, very briefly. Clause 5.3 of the Charter Party specifically addresses fumigation and notes that fumigation ordered after delivery of the vessel is for charterer's account. That should be the end of it. Second, if you are not with me as regards that point, it is fundamentally for charterers to prove that the owner's choice of yard was unreasonable in all of the circumstances, recalling that war had broken out, that an alternative yard was available, recalling war had broken out, and that another yard would in fact have avoided that contamination. If they cannot do so, we return to clause 5.3, and the costs of fumigation are for their account. Now, the very final aspect is with regard to cargo. I understand that charterers are making a claim for an indemnity for any losses caused to them for diminution to the cargo that they face from cargo interests. Now, it should be uncontroversial because of the clause paramount. In the Charter Party, the Hague-Visby rules are included not only in the Bills of Lading but also in the Charter Party, and they are back-to-back, therefore the issue should not arise. So unless I can be of further assistance.
Thank you, Mr. Diebschlag.
Thank you very much. Just one question each. I request the answers to be very short, please. Ms. Young, you mentioned about the owners expressly requested your clients, the owners expressly requested the respondents for declaring another loading port. So can you reconfirm? Yes, did they request them expressly or passing master's message? What was the difference?
The owners passed the master's message which contained the request for cancellation of the order to the respondent. And we say that in doing so, the owners already exercised their own judgment by not adding any further elaboration or expressing contrary views.
Okay, thank you. And one for you, Mr. Pride. Can the owner take the vessel for repairs at any time and expect the hires to be paid?
If to do so is reasonable, yes, you can do so. Carver on Charter Parties is reasonably clear about that. Further, if we have to do repairs on the basis that charter has caused damage, you can conduct other repairs at the same time, and hire continues to run during that period.
Thank you.
Thank you. It is now time for Ms. Coco Jeng to open the case for charterers' arguments in response. Ms. Jeng.
I appear on behalf of the respondent with my co-counsel, Ms. Maggie Lee, and this is the respondent's opening submissions in position to the claimant's claim in the sum of around $2 million US, and in support of the respondent's counterclaim in the sum of $1 million US. And for the parties have prepared the statement of facts for the tribunal's perusal, which contain the facts that have been agreed by the parties previously. But unfortunately, just at the last minute before this hearing, the claimant's counsel produced the slides showing the facts literally gathered from public available information. But such facts have not been addressed or pleaded in the previous pleadings, and the respondent has been deprived of a reasonable opportunity to review and address such facts. So the respondent has taken reservations of such an approach to deal with the cases.
Are you applying for an adjournment at this stage?
The respondent submits that the respondent invites the tribunal to give a lesser weight to such facts that have not been pleaded before.
Thank you, Ms. Cheng. Thank you.
Okay. The delivery of the vessel, the time and date is not disputed, and on February 16th, it's not denied that the master wrote to the claimant requesting for a change of the nomination of another loading port. And on the same day, the claimant forwarded this message from the respondent stressing that the timeline to load in Mariupol be February 22nd, and the importance to meet this deadline has been emphasized. And it's noted that the claimant has offered no explanation or engaged in further communication with his crew to addressing their crew's concerns, even though the claimant was fully aware of such concerns. So the only reasonable explanation is that the claimant was fully aware of the voyage charters down the chain, and the parties down the chain, they were concerned about the orders, about the importance to meeting the deadline punctually. And it's not disputed that on 17 February, the entire crew resigned. And it's alarming that the claimant's counsel has not elaborated on this resignation issue, which is also crucial in this case. And it's not denied that as a result of the resignation, the vessel had to deviate to Spain to have a crew change. And it shall be noted that during this deviation period, there was no crew members on board, and that was why there was deficiency in numbers. And it's not denied that on 24 February, the vessel arrived at the loading port and missing the deadlines by 2 days. But fortunately, the grain loading operations could commence efficiently, and the loading rate was very high, just at the usual practice of this loading port. But unfortunately, she was hit by the Russian missile, which was totally unexpected and unforeseeable, which will also be explained later. And it's not denied that the vessel sustained the damage due to the event described above, and she had to spend 10 days being repaired at the local shipyards. And finally, when the repairs was completed, unfortunately, it was discovered that the grain was infested with beetles, which called for fumigation. So it has been mutually agreed between the parties that the overrun period was of 14 days. And the respondents put on record that at no time did the claimant expressly ask the respondent for an alternative voyage order. And it has been unfortunate that the parties haven't agreed on the sequence of addressing the issues. And the respondent notes that the claimant presents its issues in the order like the first, safe port, war clause, deviation issue, off hire, and repairs and deviation. But since the respondents mentioned that it's important to address the resignation issue, so the respondent will start by addressing the crew issue. And it's trial law that owners is generally responsible for the ship and the crew, and the matter which relate to the vessel and the crew are generally for the ship owner's account. And while matters relating to the commercial trading of the vessel are for the charterers to bear. And also, according to Clause 4 of the Charter Party, the owner must provide competent and adequate crew members. So that's to say the claimant is responsible for this internal human resources management or employment of crew matters. So any consequential time spent and delays and consumption of bunker arising out of or incidental to the resignation should be on the claimant's account. And the claimant just simply forwards the respondent's email to the crew without further explanation. So the only reasonable inference could be drawn was that the claimant was endorsing or affirming the respondent's voyage instructions, which was lawful. So therefore, the claimant shall procure the crew's compliance with the respondent's voyage order, and failing which the cost and time shall be on the claimant's account. And it has been submitted by the claimant's counsel that the claimant passed the master's message to the respondent to show their objection to the respondent's voyage order. However, when the claimant received the respondent's response, it passed the same to the master, and without further follow-up questions or clarifications passed to the respondent. So the respondent was in a perfect position to think that the claimant was totally fine with the respondent's position. And not to mention, when the resignation happened, the claimant just proceeded to arrange for another batch of crew members to come aboard. So the only reasonable explanation was that the claimant was intended to strictly follow the respondent's lawful voyage orders. And as just said, the 2-day deviation amounted to deficiency of men because there was no crew members on board during the deviation. And deviation was also considered as an off-hire event under Clause 8 of the Charter Party. And it has been the respondent's case that but for the resignation and the deviation, the vessel could have met the deadline or could have arrived at the loading port well before the deadline and could even finish the loading operations, given the remarkable loading rate in Maritime port, which is a famous port for exporting grain. So they have great facilities, excellent stevedores to carry out the loading operations in a timely and efficient manner. So should the deadline be met or even be met in advance, so the vessel would not have gone through the troubles of going through being hit by the missile or the repairs or the fumigation, all of which add up to the 14-day delay. And the claimant has been arguing that the respondent has breached the safe port clause, or the BINCO wartime clause should be applicable. This is strenuously denied by the respondent. According to the BINCO article as authority number 10 submitted by the respondent this morning, the article was published on 24th of February. The respondent acknowledged that Maritime port became unsafe on that day, but BINCO did not suggest that the port had become unsafe to attract application of BINCO wartime clause before February 24th. So it's rejected that the BINCO war clause was applicable. Sorry. And as just previously mentioned, the claimant at no time requested the respondent to give another voyage order. If the claimant was genuinely concerned about the safety of the loading port, it should raise objections well in advance. And the claimant's silence or refusal or failure in doing so may be taken as the claimant also appreciates that the loading port was not that dangerous, was still a safe port before February 24th. So under the circumstances, it has been the respondent's case that the respondent did not breach the safe port clause. Even if the respondent did, which is strenuously denied, it is submitted that the claimant has waived or affirmed such breach, and then the claimant is not now in a position to make the alleged claims for damages for those claims set out in paragraph 2 of the claimant's opening submissions. And as for the the claims for the repairs. And it has been the respondent's case that the repairs could have been carried out within 5 days instead of 10 days. A double period of time would definitely consider as unreasonable. And most importantly, since the claimant has not disclosed any particulars about the repair, so the respondent has not been given enough information to ascertain the reasonableness of the repair's progress. So the respondent could only rely on the information provided by the local agent. And as for the claimant's application of Clause 14J related to the deviation to conduct the crew chain, and as repeatedly said, when the Binko-Warwick clause was not applicable, so Clause 14J was not applicable to the said deviation. And we know that the Claimant's Counsel has submitted that Clause 8 of higher clause should not be applicable as this is not an ordinary event. This corroborates to the fact that the attack happened on 24 was also not an ordinary event and also totally unexpected and unforeseeable and abnormal. And that's why the respondent has never breached the Warwick clause, the unsafe port clause or the Warwick clause.
Ms. Dunn, just very, very quickly, it's more of a clarification. You said no crew on board, so deficiency. So how long did the ship sail without crew so that there was deficiency of men?
As to the best of the respondent's knowledge, the deficiency had lasted for 2 days.
And crew was not there on board, is it? There was no crew on board for those 2 days, and hence.
Because it's the owner's vessel, so the respondent trusts that the claimant has better information in how they manage the voyage.
Can we just ask the claimant to clarify about the crew? Were they actually on board during the time of the deviation and sailing the ship?
During the deviation, the original crew was on board, but then they resigned after receiving the respondent's reply that they insist on proceeding to Mariupol.
Did you leave the ship without any crew on board at any stage?
No.
Thank you. So, Miss Lee.
First, I have to thank Coco for giving the submissions. Yes, I think I would recap the main arguments of the respondents. The first argument is about the deficiency of crew. While the owners has just clarified that there was crew on board, but the respondents, charterers, would submit that, while by the fact that there are resignation, in fact there was no people would performing the orders of the charterers, and therefore the charterers will be maintaining its argument that such deficiency will be of the crew will fall within the catch-all provisions of the off-hire clauses and of any other similar clauses where the vessel wasn't available to perform charterers' orders because due to the resignations. And the second main argument we repeated and maintained that is that when the charterers order the vessel to be sailed to Mariupol, it will be prospectively still safe, as my co-counsel reiterate that under the articles for the Binko Wartime 2013 that present situation owners should still have the right to call at the ports in that region. And at present, charters at that time was not aware of any guidelines published by the Binko suggesting that the owners was absolutely entitled to refuse to sail to Mariupol before 24th of February. And in fact, as we just mentioned earlier, that the master just forwarded the message to charterers and did not clearly expressly inviting charterers to nominate another fresh port, and we redeemed and elect that the owners had accept the risk and accept the order to proceed to the maneuver. And by the act of ordering the vessels to there, our charterers will be submitting that the owners has already accept the risk of proceeding to the maneuver port. And in fact, it was reflected in the drafting of the clause 14, while the owners have the options to elect to refuse not to proceed with to the order of the port. If they owners aware that there was real concerns of the war risk, they could elect to refuse. But if they decide to go there, then the charterers have to be responsible for paying the insurance. And in fact, such drafting of the clause will be clearly setting out the parties' intentions of allocation of risk. And so therefore, charterers argue that once the owners agree to proceed to the maneuver port, then the owner should be accepting the risk of it and should not be seeking the claim, should not be putting forward the claim for including the repair cost and the hire and etc. And the third point, we will say that at the time of the making the order going to maneuver port, that was the missile was unexpected and abnormal, and therefore it was not foreseeable to charterers. And finally, turning to the CACO devaluations, charter would like to invite the tribunal to consider that the owner's duty is not just reasonable in maintaining safety and repair, but an absolute one. Further, alternatively, if this argument was not accepted, as my co-counsel just mentioned, that we will maintain the position that 5 days would be a reasonable period rather than 10 days, which was unduly long, and therefore the time loss as well as the subsequent cargo damage should be on the owner's account.
Thank you very much. Could we just clarify something? Are you now saying that clause 14, the war risk clause applies, and you're now agreeing that the war insurance and the bonus should be payable by charterers pursuant to that clause? Just so I make sure I've got that.
Bonus case has been that the cost, such cost has became applicable from 24th February, when the military action happened.
Sorry, just to clarify, you're saying that you agree now that clause 14 applies and that the insurance and the bonus are payable, but only from the 24th?
Yes, that's the case.
Okay, many thanks. I think owners will be submitting in reply. Am I right? Ms. Young.
My client does not dispute their obligation to provide crew, and that for the 2-day deviation, the crew has already resigned, and that may fall under the off-hire clause. But we say that the resignation or the deviation was in fact caused by the initial breach of the safe harbor clause by the respondent, and so they cannot rely on the off-hire clause. As my co-counsel has pointed out, that they cannot take advantage of their own wrong, which is the breach of the charter party in the first place. And the respondent also argued that by my client forwarding the reply to the original crew, my client endorsed or affirmed the order to continue to proceed to Mariupol. But by the same logic, then my client also endorsed or affirmed the request for cancellation of the order by forwarding master's letter to the respondent. My client never unequivocally represented that they would not treat this as breach of the safe harbor clause by the respondent. And as mentioned by my co-counsel from the Kanchenjunga case, even if my client has accepted respondent to proceed to the unsafe port, they only waive the right to refuse the nomination, but then they can still claim for damages for the cost of repair, which is damages flowing from the breach of safe harbor caused by the respondent. And the respondent also argued that my client immediately arranged for replacement crew, which shows that my client affirmed the order. This is denied because my client was only acting to comply with their obligation to provide under the charter party, and they are left with no alternative with the vessel sailing and the original crew resigned. As for the repairs, the respondent is alleging that my client has breached their maintenance obligation, but they have not provided any particulars of the breach, and the burden of proof is on them to give such particulars.
I only have two points to add. One is that in order to waive your rights, you need to have made an unequivocal representation that you are doing so. We did not do so. The second one is as to whether owners had an obligation to request another port. Yes, we could have done so. However, it is to muddy the waters to suggest that we needed to do so or that you can read anything into owners' silence. Fundamentally, it is charterers' obligation. It is a continuing obligation to nominate a safe port. You can see this from the EVIA, which is here. This is page 320 of the case report. There may be circumstances, this is Lord Ruskill, there may be circumstances in which, by reason of a port which was prospectively safe when the order to go to it was given, it subsequently becomes unsafe. And on its true construction, this imposes a further and secondary obligation on the charterer. And Lord Ruskill then identifies two situations. And the first situation is on all fours with where we find ourselves now. And this is where the vessel, while she is still proceeding towards such port in compliance with the order, new circumstances arise that render the port unsafe. In this situation, it is my opinion that on its true construction, unless the cause of the unsafety be purely temporary in character, and I think we can recognise that it has not been, it imposes on the time charterer a further and secondary obligation to cancel his original order and, assuming he wishes to continue to trade the ship, to order her to go to another port. That did not happen.
So the tribunal thanks the parties for their very helpful submissions, and have we?
As we agree that both sides can make reply submissions.
I'm obliged. I will not cut you off then. Ms. Jiang.
Claimants cancels reply submissions. First, when the safe clause was not breached, of course, the respondent could rely on the off-hire clause, even if there were crew members remaining on board the whole time, and they refused to carry out their duties, which could be categorized as strike, which was also an off-hire event under Clause 8. And the claimant repeatedly said that they forward the master's message to the respondent as a request for an alternative voyage order. As said before, when the respondent received such message, the respondent did reply and insisted on the original orders, and no follow-up questions and nothing in objections has been passed to the respondent. That's why the respondent was entitled to take the claimant's silence and the claimant's conduct to carry out a crew change as affirmation or endorsement of the respondent's voyage order. And it's acknowledged that the claimant has no right to request an alternative voyage order when the claimant sailed the vessel to the loading port in question. And the claimant was entitled to claim for damages, but the condition of claiming damage was that there was a breach in the first place. Since the unsafe port clause have not been breached and the warranty clause was not applicable, so the claimant was in no position to claim damages. It's indeed the respondent's burden to prove that the duration of the repairs was unreasonably long, But since the claimant did not provide any particulars of the repairs, which is highly relevant and material evidence, so the respondent was placed in a difficult position to fully plead its case. And it's not denied that the loading port became unsafe eventually, but that was totally unexpected and abnormal. That concludes our reply submissions.
Thank you, Ms. Jiang. And the Tribunal thanks the parties for their very helpful submissions and all the huge amount of work that has gone into your written submissions as well, which perhaps haven't been distributed to the audience. I think it's just been limited to the statement of facts. So many thanks indeed. Now, that marks the end of the hearing proper, and if this were a real arbitration, Clyde & Co. and High One and Partners would pack up and leave the room, and that the three arbitrators would be left here, and we would have a great opportunity to discuss our views, completely confidentially with just the three of us. And it's been suggested that you will find it interesting to hear our thoughts and deliberations. Let's test that, shall we? So, as chairman, I will kick off, because I don't know how the audience is feeling, but a huge number of issues have been raised. We've got a huge shopping list of shipping law issues, but I think that the most important issue that is coming out of it is the question of safe port and this so-called secondary obligation, because everyone accepts that the primary obligation when Charterers originally nominated Mariupol, there's no question it was safe, but then we get into mid-February, the crew refused to go, and then there's this question about, is there a secondary obligation, and if so, are charterers in breach of it? Now, without going into resolving a factual question about the actual safety of that port, just for the sake of our deliberations, let's assume that as at 17th February, when the crew resign, let's assume that Mariupol had indeed become unsafe, just for the sake of argument. Let's assume Mariupol had become unsafe. And there would usually, this is just my initial view for discussion, there would usually be a secondary obligation on charterers. If the first port becomes unsafe, there would be a secondary obligation on charterers to nominate an alternative port that was safe. That's almost common sense. But in our case, like the House of Lords decision in the Evia, there was a war risks clause, the con-war time. And in my view, that specifically provided for the situation of war, because you've got generally safe ports, everything, but here we had a specific war risks clause. And I think that con-war time, that war risks clause, or I'm inclined to think, open to argument, that war risks clause is like a carve-out, and that it qualifies, and none of you can argue at this point, by the way, but the audience can, that war risk clause is a kind of carve-out, and in a sense it qualifies the secondary obligation which would otherwise apply in a safe port situation. Now there is a starter for 10. Would anyone like, Jagmeet, would you like to give some more practical observations?
You see, as a owner, if I wear the hat of the owner, they are not listening, right? We are talking.
They can't argue.
Then of course I would be very worried about the port, right? So I would not just rely on master's message, send it and be like a post box. I will never be. I will insist on it that the port is safe. And somehow it does not make me happy to think that a charterer can outsource his secondary obligation by paying premium. This is my opinion. I mean, just
It's very interesting. Nicola?
I can see where you're coming from with regard to the Evia and there being a contractual insurance solution to the problem. And that seems to be what the respondents came to argue towards the end of their submissions, if I've interpreted that correctly. My only concern is that the clause we have, I think the Evia was on the Bold-Time form, but the clause we have is a Con Wartime 2013, and it's not all inclusive. For example, hire is not mentioned. So I think there might be an argument to say that the risk of having that clause in, where the owners then effectively bear the burden of an unsafe port, that may not arise because the Con Wartime isn't on the same form as the Bold-Time form. That's my initial thoughts.
Yes, I think we can confirm this is not an easy issue, and you can see why it went all the way to the House of Lords in a number of cases. The way I'm looking at it is, I think you're right, there's that difference in the clause, but owners had a veto. They could have said, we are not going to Mariupol. And it was their case that Mariupol was unsafe. There was a war on, or at least a military situation at the time. So they could have said, not safe, we're not going to go. But they instead, and as you said, Jagmeet, they made no objection, they were just acting as a postbox, and they went. And under the clause, the charterers are paying premium for war risk insurance. So what benefit do they get? If they're paying premium for the war risk insurance, the ship's hit by a missile, and charterers still have to pay the repair costs. So it's possible that if we're trying to discern the objective intention of the parties, it's possible that you could have had a deal like that. But it doesn't really give any commercial sense to that Con Wartime clause where the charterers are paying the premium, that they get something for it. But let's not decide right now, because I think we're going to reserve our decision, and I will produce, and I think CMAC will circulate this to all registrants. I will produce a decision that will look remarkably like the Evia in an award. But I'm looking at the clock in terms of time. Do you want to hear more deliberations? Fumigation, Jagmeet.
Yeah, one question which always, when you were speaking and both the parties were speaking, when the loading got over, did the charterers arrange for fumigation in the very first instance? Yes or no? So, okay, they are not this. Oh, okay, they are not.
What would you think?
Yeah, so if they have, normally the fumigation would be done. You have a long passage to Indonesia. So then to say that, okay, later on there was infestation of the cargo and the fumigation was carried out, now it has to be on charterer's account or owner's account that dispute is coming. So in the very first instance, whether the fumigation was done, that's a key question. If yes, then the quality of fumigation is another question. Why after 5 days or 10 days, fumigation had no effect?
I also think those points are very valid and ran through my mind at the beginning. But I also think there is some force to what the claimants were arguing, that the fumigation clause is a no-fault clause, and that is triggered by the cargo and it's triggered by the ports that are visited. So I think that makes it fairly simple, in my opinion, that the fumigation costs should really be for the respondents.
Do you think there was any fault on the part of owners with the repair yard?
No, I think it would be very unjust and very harsh to penalise the owners in a war situation for not having 5 or 6 different repair yards at their fingertips. But that's also something I'd like your technical view on, Jagmeet.
You see, when the ship gets hit like this, the first thought in your mind is time. Very quickly, you need to get the best shipyard, the first shipyard that you, if they are capable, you need to get them and get the work done. I mean, this is not the time that you start looking. And the most important thing, Chair and Nicola, that I found was, without knowing what work was done, how can the respondents just talk about time 10 days or 5 days? On one side, they say they haven't got the details. On the second side, they insist it has to be 5 days and not 10 days. I find that it is surprising. You're not listening.
There is one point that might be relevant for our later deliberations, and that is whether the claimants, by their conduct, had basically accepted the orders and had agreed to go to the port, and then whether that was a reasonable thing to do, bearing in mind the claimant's reliance on the Kachanga case. We might have to debate that for some time, but that's something to look at.
And I think, Jagmeet, you can just, before we close, make an interesting observation about the Kanchenjunga.
The Kanchenjunga, that's, as I mentioned to you, the case which we see here is not the one which I was mentioning over lunch. That happened later on. That happened later on. The vessel had two issues. One, of course, is this is the time ship goes there and then she leaves without damage. That's all. And after, I think, a couple of years, she gets hit by a heat-seeking missile and the missile goes through the funnel and the explosion basically explodes. The entire accommodation, explodes. So I was talking about that. I saw it in front of my eyes. I was on Long Phoenix, sailing on the ship.
Fantastic. So with the benefit of that initial discussion, it would then be decided who would write the first draft of the written award. And I think as the presiding arbitrator, I will do that. I'll produce the first draft that I will circulate to Jagmeet and Nicola, and then we will discuss some more before we reach our conclusions, because there is a whole shopping list of claims that we have to run through, cargo claims, off-hire, etc. This is an arbitration under the CMAC rules, and you may be interested to know, and Brad will correct me if I'm wrong, but under CMAC rules there is a 6-month deadline for delivery of our award. And you're thinking, 6 months? Easy. The 6 months runs from the date when the tribunal was constituted. So I've got to dash off immediately after we've finished. And also our award will be scrutinised by CMAC under Article 60 of the CMAC rules. So it's lightly administered, but it is administered all the same. So back to you, Donald.
Thank you so much, arbitrators and counsel, for the excellent performance. I personally find it fascinating that when a tribunal consists of arbitrators having different expertise, the interflow, the exchange of ideas is really fascinating. I mean, this may be so much better than the situation where 3 arbitrators are actually lawyers and they have no other input from other expertise. Like, there's something which are some food for thought, I think. Thanks to the efficient conduct of the arbitration and time control of the counsel, we are a little bit out of time. That proves that, when properly managed and organized, arbitration could be really efficient and resolving disputes. This brings us to the end of the mock arbitration hearing, and on behalf of the organizers, I would like to thank all arbitrators, all counsel teams, all attendees today for your support to this arbitration. And last but not least, I would really like to thank the transcribers for their excellent work and in producing these live transcripts. I'm always amazed as to the speed and the accuracy in which these transcripts can be produced immediately. Okay, so thank you very much. I hope to see you all next year again. Thank you.